Good morning, good afternoon, and good evening. Whatever time you are watching this, thank you for tuning in. This is another edition of Voir Dire, the Crime Talk edition. First of all, I'd like to give a big shout out to my former current and fellow Marines. Happy birthday, and wish a happy Veterans Day to everyone who has served or families that have served of those veterans. The United States would not be such a great place that we are without our veterans. So let's jump right into it. First thing I'd like to talk about is the Christopher Watts case. And as most of you know, Mr. Watts pled guilty last week. I was hoping that I was going to be able to get up there and do it myself, but I was held up in court, and so I had to send an associate. He sent me a couple of interesting pictures while he was up there. And since that time, we have also obtained a copy of the actual plea agreement in this case. This is what they call the Rule 11 Advisement and Plea Agreement. And as you may recall from the last conversation we had, we discussed what is in a plea agreement. It explains the Rule 11 Advisement. It explains what you're pleading guilty to, the right you have, the right you give up, and possible penalties. And in this particular case, everyone pretty much knows that he pled guilty to all 9 counts. And the first count is murder in the first degree after deliberation for Shanann Watts. Count 2, murder in the first degree after deliberation, Bella Watts. Count 3, murder in the first degree after deliberation, Celeste Watts. Count 4, murder in the first degree, child under 12, Bella Watts. That is basically the position of trust since he is the father. Mr. Watts was the father of Bella Watts. And count 5, murder in the first degree, child under 12, Celeste Watts. Once again, that is a position of trust charge. All of the first 5 counts are Class 1 felony offenses. Murder, basically life without parole, never getting out. Whether it's count 1 or 2 or 3, those all have to be consecutive. So we know he's going to get at least 3 life sentences plus a bunch of other time as well, because counts 4 and 5 will merge since it's really the same conduct in count 2 and 3. Count 6, unlawful termination of a pregnancy in the first degree. That's a Class 2 felony, so it will carry 16 to 48 years on top of the multiple life sentences. And then tampering with a deceased human body, 1 for each victim. That's a Class 3 felony, so he is looking at 4 to 16 years, and the court could make those all consecutive. Not that it really matters, it's academic, but it is still significant that he's going to have that big of a punishment for him. So the plea agreement further goes on and says all sentencing options on all counts are open to the court. However, in exchange for defendant's guilty pleas, the Office of the District Attorney agrees that it will not seek the death penalty. Whether sentencing on separate counts run consecutive or concurrent to each other is open to the court, with the exception that at minimum, the parties stipulate that sentencing on counts 1 through 3 and count 6 shall run consecutive to each charged references a separate victim. Defendant will not be permitted to waive a factual basis for any charge. So, a couple things I want to talk about right there. Kind of already mentioned this, but counts 1 through 3 and count 6 all have to be run consecutive. So he's going to get 3 consecutive life sentences plus 16 to 48 consecutive, probably get 48 on that. Like I said, really doesn't matter. But the significant thing is defendant will not be permitted to waive a factual basis for the charge. And what that means is that he basically has to admit in open court the factual basis. All right? When one pleads guilty, the court will ask, will you stipulate that there's a factual basis? Are there facts to support that charge? The defendant, through his attorney, will usually say, we waive the establishment of a factual basis. And basically means, I'm pleading guilty, but it doesn't really matter. Here, the district attorney required him to basically admit that he killed his daughter, Bella, and Celeste. Now, why is that significant? It's significant because, for whatever reason, let's say between now and sentencing November 19th, Mr. Watts has a change of heart and he says, I want to withdraw my guilty plea. My attorneys rushed me into this. I wasn't a full no involuntary decision. Even though I said that on the record, Judge, completely disregard that. it could happen. I don't think it will, but it could happen. All right. And the other thing is that he has to basically admit it, and it completely contradicts what he told the police in his first statement to them, where he said that the children were killed by Shanann. So they wanted that. My guess is they probably wanted that for the family so that they could have peace of mind that their daughter did nothing to harm her children. Now, I have had several questions on people. I've had several questions from people who have asked me about the plea. I wish I was there. Cameras weren't permitted in there. I have ordered a transcript of that hearing because I have heard reports, or people have asked me if it's true in the comment section below. Is it true that, one, Watts cried, and two, that his attorneys were pressuring him or in some way trying to get him to admit counts 2 and 3, the murders of Bella and Celeste? I don't know. I've had my assistant ordered that transcript, so hopefully we'll have that shortly. All right? So that's a significant thing that I thought from the plea agreement as well. Additionally, he has to pay for all restitution, which could include the funeral and burial expenses. Pretty unlikely that he'll ever really pay anything. Any money that is sent to him that will be on his books at the Colorado Department of Corrections will get garnished, but it's a very small amount, and frankly, it doesn't matter. He's not going to be earning his 6 cents a day for working or anything like that. He'll probably be in solitary for his own protection, at least for a while. And also that he is agreeing to pay any restitution covering the actual cost of specific future treatment. And what that means, or I believe what it means, is that if Shanann's family, parents, siblings need counseling in the future regarding these events, that he is going to be responsible for it. Does it really mean he's going to pay much of anything? No. And additionally, it says, finally, the parties stipulate that the government may withdraw from this agreement if the defendant commits a new felony offense while awaiting sentencing. So that is not necessarily unusual. It's kind of standard paperwork. Now, the other thing that's usually standard paperwork, some jurisdictions do it more frequently than others, but they do an evidence disposition, stipulation, and order, all right? So what that means is basically everybody agrees, hey, at some point in time, there may be evidence and we're going to dispose of it. Why anyone is agreeing to dispose of this evidence is beyond me. Mr. Watts has pled guilty. He will be sentenced on the 19th, but he has a lot of time ahead of him in the future to think about this case. He is going to have a lot of people giving him jailhouse advice on what he should have done. He has been basically, as I understand it, in solitary confinement. He has no idea what's going on. And as I have said, whether Mr. Watts told his attorneys to go and get him a deal, we may never know. We understand that they approached the district attorney, but they could not have done that without Mr. Watts' permission, all right? But he hasn't had a whole lot of time to think about it. He may say, you know what, I didn't do this. I didn't kill the children. I'm going to come with a defense. I was crazy. Who knows? So over the course of a lifetime, he has an unlimited amount of time in this particular case, because it is a class 1 felony, first-degree murder, to basically file what they call a 35C. And that is basically to allege that his attorneys were ineffective and that they didn't do what they should have done for this particular case, and that it wasn't a no involuntary decision. He should be allowed basically to proceed to trial. And why is that significant? Because here everyone's agreeing to destroy the evidence. It says the defendant understands that evidence being held by law enforcement agencies in this case could contain DNA. The parties stipulate that, and then it goes on, that evidence that has not been tested could be subjected to DNA testing. Yes. The case includes DNA evidence that should be preserved. No. Okay. And then it lists what his charges are, and then it basically says there's an evidence log, and we can go through and decide what needs to be deleted. And it says the defendant agrees, and the court orders that law enforcement may discard, destroy, or return all items of evidence set forth on the attached log, and that evidence will be released according to law enforcement agencies' procedures, and the defendant waives any right to further notification before this evidence is released. And then it goes on and says, a photo ID is required for release of evidence. The representative of the defendant who may collect the property is, and it's a representative, Mr. Watts' family. And so that's it. So he's going to get anything that he's entitled back. Who knows? It could be pictures, photos, wallet, whatever. Why anyone is releasing any evidence of this is simply beyond me. So I think that begs the question. This plea disposition, will it blow up? All right? I hope it doesn't. All right? People need to get on with their lives. In regards to the family, Mr. Watts needs to get on with his situation. But it could happen. And here's the other thing. Did Mr. Watts get punked? All right? Let's face it. The plea agreement says that the DA agrees not to pursue the death penalty based upon his plea to all 9 counts. The DA says that he went to the family of Shanann Watts and talked with them about whether they wanted to be involved in this case for the next 25 years if the death penalty is pursued. The district attorney, Mr. Rourke, also made comments that it's very unlikely that the death penalty will ever be imposed in this case. What does that mean? If someone is sentenced to death, assuming you could get a unanimous jury to agree, because it only takes one to say life, and he gets life without parole. It's very unlikely that the death penalty would be imposed. Right now, there are, I think, 3 people in Colorado on death row, and our governor, current governor, who wants to run for president, has granted clemency to an individual who killed several people some 20 plus years ago. And basically, the governor said that his position on the death penalty has changed. And I can tell you, the newly elected governor here in the state of Colorado has already stated that he would not impose the death penalty because he disagrees with it. So the fact of Mr. Watts being put to death anytime soon is very unlikely. All right? So I'm not really sure why this plea deal was sought so quickly. Given the video evidence that I've seen on Facebook about Shanann's conduct, the treatment of him, I mean, there are so many things that could have been done to present a defense for Mr. Watts. Understand, I'm not trying to defend him. I'm not trying to say that Shanann Watts did anything wrong. Frankly, I don't know. But as an attorney who would have been charged with representing Mr. Watts, I cannot believe that basically over the course of a month and a half, the public defenders decided that they could do mitigation on a potential death penalty case, do a factual investigation, and do that. Hopefully, they documented their file absolutely, completely, thoroughly, that they were seeking this plea disposition at his behest, and that they advised him that it is against his best interest to do that. So that'll be interesting. Another update. We've been in contact with the coroner's office, and specifically we received a response from the county attorney because we want a copy of the autopsy. Oh, pardon me. And we want an autopsy for all 3 individuals in this case, Shanann, Bella, and Celeste. And the county attorney, who is representing the coroner, has stated that they are not going to release the autopsy until the sentence of Mr. Watts is done, and then 24 hours after that, once it is absolutely finalized. Which I think is ironic because there's actually still a hearing scheduled on the 19th before a different judge than Judge Kopkow to decide whether it should be released, and it's in the interest of the public that it should be released. They're all but conceding that it should be released, so I'm not sure why we're waiting for anything. But that is what they're doing, and I'm not sure if it's coincidence that it is the sentencing is set for the same day as the hearing, which was set for the release of the autopsy. But either way, we are going to get a copy of it after the 19th. So this case will linger for years because I think there's so many unanswered questions, and the fact that it has not been given basically a complete vetting in not only the court of public opinion, but the trial court. It shocks me that it resolved so quickly, given the lack of time. Very rarely would anyone plead guilty. We hadn't even been to the preliminary hearing stage where we would have received more information. The defense could have used it as a discovery tool to develop theories. It's absolutely flabbergasting to me. And the fact that everybody knows here in Colorado that the death penalty, pretty unlikely that it would ever be imposed, Chris Watts got punked. So, I'm not saying he doesn't deserve it. I'm just saying I think he got played by the DAs and possibly even the attorneys that were concerned that they were going to deal with the death penalty. I don't think it was really an option in the end. Anyway, so as we have talked about previously in our previous conversations, is that I'm trying to look for interesting cases. And if you think there's an interesting case that you would like us to comment on, to further analyze and try to get a little more in depth, we are here to do so. All right. The one that I have found that I think is rather interesting, and I think it could get more interesting here, is the case in Dallas, Texas. And it's the case of Amber Geiger. All right. And really what this case boils down to is on September 6th, Officer Guyger, who's 30 years old, killed an individual that had an apartment in her same complex by the name of Botham Shem John. I believe it's John. Could be Gene, but I believe it's pronounced John. Anyway, he was an accountant, and he was basically in his apartment, and somehow this Miss Geiger got into his apartment, even though they have electronic key cards, and basically shot him dead. All right. And it's absolutely amazing to me that this woman is a police officer, and she wasn't charged with first-degree murder. She was charged with manslaughter. But here's why I think this case is going to get interesting. One, it just doesn't make any sense, all right? First of all, the apartment that she went into, of Mr. Gene, his apartment was on a different floor. He had purposely placed out a floor mat which distinguished his apartment from that of others. It had an electronic key card, whereby you needed that key card to get into the apartment. The shooter in this case, Officer Geiger, says that the door was ajar, but the door slams automatically. It closes automatically. And so you couldn't leave it ajar unless you actually put something into the door and the doorway to do that. So somebody is not telling the truth here in this particular situation. And so why I think it's going to get really interesting is there was an election here just earlier this week. And the significance of this is that the district attorney who originally charged Ms. Geiger only charged her with manslaughter. But now the new elected district attorney believes that it should be a first-degree murder case. And so what will be interesting is whether the new district attorney in Dallas will seek a superseding indictment and file first-degree murder charges versus the manslaughter charges that were previously filed. I think this case is going to get interesting because it literally brings up so many issues as it relates to what's going on in the world today. You have a police officer. Did she get a pass? Okay. She's a white police officer. The victim in this particular case, from what we can all tell, had done nothing wrong, was sitting in his own apartment when he was shot and killed by someone who had no permission to be in there. And I think it's very hard to say that she somehow just happened to wander in there by accident. That's just something that was not right. Something doesn't make sense. And obviously, Mr. John is a black man, but a successful individual. He's a CPA, worked through college, was doing everything wrong. He's not some punk on the street. So this is going to be interesting whether justice really will prevail in this particular case and what it will be. It sounds like it will ultimately be up to the citizens of Dallas, Texas to decide the ultimate fate of Miss Geiger, but it is going to be interesting, and I think it opens up lots of issues that need to be further discussed. So that is going to wrap up today's edition of Crime Talk. And so what I would ask you to do, if you like the channel, subscribe, like the video, and hit that little button over there on the side of YouTube, and we'll send notifications. Have a great day. Thank you for taking the time to watch Voir Dire Crime Talk Edition. We know there are lots of choices out there, and we appreciate that you watched this show. Please like, please subscribe, and we will see you next time. Have a great day.